as we begin today's webinar, I just want to acknowledge that we're meeting today on Indigenous land. The Division of Socioeconomic is located in Saskatoon on Treaty 6 territory in the homeland of the Métis. And as a white settler and guest living on this land, I am very grateful for the opportunity to meet today on this land. In the DSA, we continue to learn about the history of systemic racism and discrimination for Indigenous peoples in this province and in Canada. And we continue to grow our understanding of how that history is alive today in our systems and society. And this week, of course, has been a very difficult one with the news from BC that's all too real for many Indigenous people who faced and continue to face the devastating impacts of colonization in Canada. So on this note, before we get started, I just wanted to pause here for a very brief moment and just to invite you, wherever you're joining us, to do your own silent acknowledgement of the land. And yeah, so I'm just going to pause for a moment for that. And in this moment of pause, I also just would like to invite you to connect in with what brought you here. And if it feels comfortable for you, maybe just take a few breaths on your own time. You know, maybe just shifting your gaze away from your computer. Maybe just noticing the weight of your body on your chair, wherever you're sitting, noticing your feet on the floor. And just using these breaths as an opportunity for your thoughts to settle, to check in, notice how you're doing, notice how your body's doing, and what you're here for, what brought you here today. And if you feel comfortable, maybe sharing one or two words that maybe came up for you, just noticing what's going on and just noticing what's coming up for people and for what's present right now for us here. And just acknowledging that, you know, we're having this conversation after a hard week that's been heavy on many hearts. And so as we go through this conversation today, I invite you to hold yourself gently and acknowledge that this conversation has different impacts. So show up the way that you need to. And so however you got here, welcome to this space, to this conversation, and we really appreciate you being here. And on that note, I'm going to pass this over. I'd like to introduce the director of the Division of Sustainability, Dr. Manuela Vale Castro, to say a few words and to introduce our guest speaker.
Thank you so much, Erin, for those thoughtful words and for getting us started in such a thoughtful way. I agree that it's been a very difficult way of entering this month of June, which of course we're celebrating Pride and we're celebrating Indigenous Month as well. But yeah, as you said, we're making sure that this week we're holding our Indigenous relationships close, not burdening them with questions, but actually offering support and renewing our own commitment to learn the histories of racism and colonialism in Canada, and to demand truth and justice before reconciliation. And I'm so honored today to have our guest, who I so admire her work. It's Alisa Lombard. She and her pronouns. And she's a devoted citizen of the Mi'kmaq Nation, Elsie Booktook First Nation, and a published lawyer with extensive experience in complex legacy and policy issues relating to Indigenous Crown relations and reconciliation in national and international forums. Alisa has been involved in and acted for many First Nations in a variety of complex, specific claims, including pre- and post-Confederate illegal reserve and land takings, various breaches of fiduciary obligations, mismanagement of Indian monies and assets, Crown failures to uphold treaty promises and to create reserves. Alisa is a lead counsel on a proposed class action pertaining the forced sterilization of Indigenous women in Saskatchewan. For her advocacy in this matter, she was recognized in Chatelain's Women of the Year in 2018. She has appeared before levels of courts, including the Supreme Court of Canada, administrative tribunals, and international committees and commissions, including the United Nations Committee Against Torture and the Inter-American Commission for Human Rights. In 2019, Alisa was nominated for the International Bar Association Award for Outstanding Contribution by a Legal Practitioner to Human Rights by her peers at the International Justice Research Center in San Francisco, California. Alisa is currently pursuing a master's in health law at the University of Ottawa with an emphasis on policy and ethics. So we're so glad to have you here today, Alisa. We're so excited that you have the opportunity to talk to our community here about what you have learned and what we should know about the elements of legal consent when it comes to medicine. So good to see you.
Thank you for having me and for sitting for a whole hour and listening to me go on about what I'm going to talk about. I just want to say I'm a Mi'kmaq woman. I'm a lawyer. I'm also a mom and a wife to a Nehiao, a Cree man from this territory, which is why I find myself here. So though I'm not Cree, I made two little Crees or Mick Crees or Cree Macs, however we want to call them. And they're 2.5 and 4.5. And so life is very busy, especially these days when we have to explain to them why they're wearing their orange shirts this week. And, you know, I really have to thank the moderators of this panel for the way that they started this session. I don't think I've ever gone into a session, a public speaking session, where it was started that way. And from my perspective, I can say that I think that was very thoughtful and kind and respectful. And thank you for that. It does give us a moment to just ground ourselves in the difficult topics that we have to discuss. And so what I like to do is really in these kinds of forums and with respect to these kinds of opportunities, I really like to talk about the legal elements of consent because they're very clear and they've been around for a very, very long time. And, you know, to be honest, given the news of last week, I've not had the sharpest mind onto these elements these days, and so my master's thesis is languishing as a result. And it feels like feels a little silly, you know, to have to continuously have this conversation about bodily autonomy and what it means in law and how it must absolutely be respected. But it's important, and so this is what we will do. I think that it's important to understand that the inalienable right to bodily autonomy existed in the Bill of Rights. It continues to exist in the Canadian Charter of Rights and Freedoms, and that it is overlaid atop a history of eugenics. Mm-hmm. And I've taken to saying recently that the failure to respect the legal elements of consent gives rise to an iteration of neo-eugenics. Now, what we did here in the Joyce Eschquan inquest, which was also very difficult, was that Joyce, who died while being treated with contempt and berated with racist words in Joliette, Quebec, had actually been sterilized just a 1.5 years prior, and that her husband reported to the inquest that she had been coerced into 3 terminations. And this was one of the reasons that she didn't want to go to the hospital. So I think it's important for everyone to understand that this issue is not historic. This issue is now. There are women that I represent who are younger than me. And I like to think that I'm young, but I don't think I'm that young anymore. And so this issue is not something that we talk about as a relic of the past. Systemic failures to respect the bodily autonomy and self-determination of Indigenous women and other women's rights over their bodies have suffered great disrespect in the last century and up until today. And unless we do something about it that is meaningful, and unless we understand these legal elements of consent and why they exist, that practice will carry on. And it is not something that I, as an Indigenous woman, am prepared to accept for my two daughters. And it is not something that that I should have to explain to them. My articling student is giving birth at this very moment, and I know that it is something that is circulating in her mind. And these act as, thieves of otherwise very precious moments. And I think it's important for people to understand that from a human perspective. And that's my attempt to human-splain this issue. And so carrying on, I imagine, though I should not assume, that most present today are familiar with eugenics policies and what they were about, who they disproportionately affected, and what the consequences of that was. If you are not, I strongly encourage you to read Dr. Erica Dick's work, Dr. Maureen Lux's work. I believe that they're all at the University of Saskatchewan, because they have done some very deep dives into these issues. They provide historical facts, excerpts from historical documents. And if there is any doubt that this practice disproportionately affected Indigenous women and other women of color in the Americas, I encourage you to look at the evidence that they put forward. So, on to the legal elements of consent. It's important to know first and foremost, and this is an unlikely commencement to this discussion, but it is perfectly legal for sterilization to be performed where the patient provides valid consent. The key word there is valid consent. What is it? What is valid consent? And although there's been much discussion about what it may mean or what it doesn't mean, what we do know is that there's a significant amount of case law from as long ago as about, 70 years ago, 1949, that talks about this in a reproductive context. And so what I want to do is I want to go through those elements. There are 4, and we're going to break them down. And I encourage you to step in. I would prefer this to be a conversation rather than a talking at. I'm uncomfortable with the talking at concept. And so if you want to chime in, subject to anything the moderators have to say about that arrangement, I just strongly encourage you to. And so consent is established through a series of legal cumulative requirements. Now, in law, when we use the word cumulative, it means there's 4 and all 4 have to be fulfilled. So not only number 3 of 4, not only the first one of 4, they all have to be fulfilled. If any one of them falls, there's no valid consent. Okay? So where procedure is non-essential, non-emergent, and non-therapeutic, such as a permanent form of birth control, and I think the literature is of one mind on that. A permanent form of birth control is never an emergency. It is never done for a particular medical reason, and it is always non-essential at the time of birth. That means that the requirements of consent are actually amplified, right? So we're not talking about an emergency C-section because baby's heartbeat is lessening. We're not talking about a woman with preeclampsia whose blood pressure keeps rising. We're talking about a procedure that is elective, that can be performed later, and that there is no risk to the woman's life in just holding off until she's in the right headspace to make a permanent decision about her fertility. So it is actually incumbent on the doctor, and I think those in attendance here will be very interested in knowing this, who is obtaining the consent, to prove that the patient's consent is legitimate, that it is valid. And so it is the physician who has to assure themselves that that consent is valid. So legitimate consent or valid consent must be firstly, voluntary, which means it has to be free from coercion or undue influence. Secondly, it has to be provided by a patient with capacity, which is, as I'm sure you can all understand, an issue when you're pushing a human being out of your body. It has to be referable to both the procedure and the operating surgeon. It has to be specific to them. So if this discussion about a tubal ligation occurs and you're saying, there's a bunch of different ways to do a tubal ligation, and the woman says, well, I may want to have it reversed at some point, and assuming she's in the right headspace to have this discussion and not going through the throes of labor, and she says, well, I may want to have it reversed, so which one has the better chance of reversal in case I change my mind? That is a very important component of the discussion. And it also means that the consent has to be informed. And the doctrine of consent contains these 4 pillars that I just mentioned. And the informed consent component is kind of like a doctrine in and of itself. It means that there has to be full disclosure of the risks, the consequences, the benefits, the options available. And again, the onus is incumbent on the doctor to prove that all of those elements have been met. And that authority has existed since 1980 in a case called Vale versus Hughes. It went all the way up to the Supreme Court, and it's been taken up by all kinds of cases across the country, saying it is the doctor's obligation to prove that valid consent was obtained. And so if we talk first about voluntary consent, one of the important criteria is that it has to be free from coercion and undue influence and any misrepresentations. Consent is vitiated if obtained in any of the aforementioned circumstances. So if there's misrepresentation, if there's undue influence by a third party or the physician or the nurse, no consent, doesn't exist. It's also important to understand, I think, that consent is not an event. It's not a signature on a form. It is not a single conversation. It is a process. Consent is a process, and it requires, as I was saying earlier, cumulatively, that all these elements be met. So where there's a power imbalance such that persuasion and influence of a third party on a patient is so extensive that genuine consent cannot be verily deemed as voluntarily and freely given, the physician should discuss the matter with the patient alone. English courts have upheld the refusal of consent as subject to being vitiated by undue influence. So if you flip the other side of the coin, and for example, if you take a case like Millet versus Schulman is a case where there was a patient who was brought in an emergency situation, required a blood transfusion to save her life. Physician was aware that the patient was a Jehovah's Witness and starkly against any kind of blood transfusion, performed the blood transfusion anyway, was held liable in battery. And I know how that can rub up against, the obligations of physicians and how that becomes very much of a moral question. But at the end of the day, bodily autonomy has no qualifications. Bodily autonomy is absolute, and it can only be infringed through proper and informed consent. So the authenticity of consent was at issue in a case called Norberg versus Weinrib. And this case was in 1992, and it'll be interesting to know that the plaintiff in this case, Weinrib, was actually an Indigenous woman. There was no discussion by the Supreme Court about that. And it was a situation where the older physician, male physician, had discovered that his patient had a prescription pill addiction. And very long story short, there had been an understanding, or not an understanding, but a situation whereby the prescription of those pills that Miss Weinrib was addicted to at the time were being provided on the basis that Miss Weinrib would perform sexual favors for Dr. Norberg. Now, this, of course, went quite some distance in the courts, and Dr. Norberg's argument was that because he was such an elder gentleman, that in fact he was the one that was susceptible to manipulation by his patient. The thing about that is that physicians and patients have what's called a fiduciary relationship because there's a differential of power, right? And that's something that we often hear in our communities and Indigenous women saying, you know, these doctors, they have all this power, they have all this authority, they know all these things that I don't know. So I just listen to what they tell me. And I can say, I do the same thing. I had a baby 2.5 years ago. And if the doctor would have said, jump on your left foot, it'll hurt less, that's exactly what I would have done. Because you don't know. You're powerless, you're extremely vulnerable. And we trust, although sometimes we ought not. So in a particular case, the Supreme Court of Canada summarized the nature of that relationship and said, in view of the inequality of power between the parties, meaning the physician and the patient, the exploitative nature of that relationship and the patient's vulnerability as a result of drug dependence, her consent to sexual activity was not voluntary. And accordingly, the physician was held liable in battery. Battery is very serious. Battery is a very serious civil finding. And so again, that was in the Norberg versus Weinrib case. Now, the law says that every effort has to be made by doctors to acquire consent from a patient whose judgment is not affected by medication in an environment free from coercion. Now, there is a presumption in law, which is subject to a rebuttal, which means the doctor can prove otherwise, that consent was not voluntarily provided. And so you don't walk into a situation bearing the benefit of the doubt. The physician has to prove in court that they obtained proper and informed consent and fulfilled these 4 elements of consent in law. So any fraudulent misrepresentation by the doctor with respect to the nature of the procedure completely vitiates consent, but only where the doctor has intentionally misled the patient. So little mistakes will usually fall into something like negligence, not battery. Battery is reserved for the more serious cases. The second element of consent is capacity. And this is a really important one in the case of forced and coerced sterilization. If a person has the capacity to consent, then the consent of other persons is not required. There was a lot of discussion, I think, 20, 30 years back, even until recently, that, doctors would seek consent from a woman's husband or spouse or partner for that woman's sterilization. No fly at all. So while shared decision-making between spouses, I guess, is ideal, a patient has a legal right to make decisions for themselves as a function of their bodily autonomy, which is protected under Section 7 of the Charter. So to assess this, a functional assessment is required. And it first involves whether the patient is capable of understanding the nature of the procedure, and secondly, whether the patient actually understands the nature of the procedure. Now, those two things look very similar, but they're a little bit different. And the former criterion is the dominant factor. So whether they are capable of understanding the nature of the procedure is the dominant issue. And the latter criteria, whether the patient actually understands the nature of the procedure, kind of assists in answering the first question. This is how we function in law. We have all these tests, and some elements rely on other elements. And although each of these items are subject to their own entire body of law, the concept of voluntary consent and capacity are linked with respect to birthing Indigenous women. So a patient who refuses consent to a procedure, while others may view as beneficial or necessary, is not an indication of incapacity and thereby default to a third party to obtain consent. And the court said, with respect to this, which was discussed in a very important treatise, in the cases Millett versus Schulman, which is, one of the important cases here, that, and I quote, patients have a fundamental right to make their own treatment decisions. As Justice Robbins noted in Millett versus Shulman, for this freedom to be meaningful, open quote, people must have the right to make choices that accord with their own values, regardless of how unwise or foolish those choices may appear to others, end quote. Focusing on the apparent unreasonableness of the patient's decision as evidence of incapacity, where the open quote refusal of consent is seen not as an assertion of will, but rather as a symptom of an unsound mind, end quote, undermines the patient's right to medical self-determination. And so what does that mean in a nutshell? It means it doesn't matter what I think or what I would do in that situation. The only thing that matters is what that woman would do in that situation that she is in. I have a few questions here, and I'm wondering if I should answer them or just carry on.
Well, you can carry on. I'm just like so inspired by everything that you're saying. So I've just put in.
Oh, there you are. That's you. Yeah.
Or whenever you want to tackle some questions, but you don't have to tackle them all.
Yeah. Okay, got it. So onto some also interesting case law in the British Columbia Court of Appeal in Smith versus Tweedale, which was handed down in 1995. So we're not talking about something new. This is, older. They dismissed the appeal of a physician who had been found negligent in the sterilization of a birthing woman on the basis that the requisite standard of care in the circumstances of birth had not been satisfied. So the Court of Appeal recognized that the state of labor and delivery required more than a routine explanation of the procedure, because of course the woman who was birthing, and those on this call who have seen it, experienced it, talked about it, researched it, will understand that, kind of hurts a lot. And there are very few things on your mind other than baby safety and your survival. Many women pass away during childbirth in many areas of the world, and that is not something that is lost on a woman who's actively engaged in that process. And so this really nudges the elements of informed consent, but it's also relevant to capacity. So the trial court said, and this is what the Court of Appeal said in endorsing the decision of the trial court, that it was persuaded that Dr. Tweedale could have been much clearer in his presentation. He could have said, "Are you sure you understand that this procedure is permanent?" Or any number of other simple things that would make someone lying on the delivery table understand clearly that there was no turning back. He did not. By his choice of language, he left the patient open to whatever preconceived ideas she may have had. And one thing that I can tell you is that before I started this case, being medically ignorant, I thought that tying your tubes meant you tied something like a rope and you could untie them. And that was it. And I think a lot of people think that, right? If they're not deeply steeped into it, the common understanding out there is not necessarily that tying your tubes is permanent, because the notion of tying necessarily implies the notion of their being able to untie. And so diminished capacity associated with labor and childbirth is typically ephemeral. It doesn't last forever, right? It lasts during labor and delivery and in the peripartum period. It's not the subject of a mental illness or unconsciousness, but rather the pain, stress, trauma, and for some, the euphoria associated with the process of giving life that essentially diminishes capacity to consider matters other than those immediately requiring attention. And the United Nations has said that it is cruel and unusual treatment, as well as torture, to sterilize a woman while she's in the throes of labor and immediately postpartum, if those elements of consent have not been met. And this is because that decision is life-altering. It alters the relations around her. It alters her relationship with herself, her self-concept as a woman, with her children, with her family, and in many cases, the case of Indigenous women, with her nation. And these are not decisions that ought to be made lightly. They are decisions that require the amount of space and specificity required by law to make. And the legal protections are there. So consent is also specific to a doctor and a procedure. The Supreme Court has said that a doctor's liability for battery arises if, emergency situations aside, surgery or treatment has been performed or given beyond that to which there was consent. So in Canis versus Sinclair, And this case was handed out in 1989. Again, not a brand spanking new case. The patient requested that her sterilization be done by clipping instead of cauterizing because she felt that clipping had a better chance of successful reversal if she decided she wanted more children. The doctor cauterized the patient's fallopian tubes because he was experiencing challenges inserting the clips. The court found the doctor liable in battery because the method used was explicitly contrary to the patient's specific request, and there was no emergency to justify deviation from the patient's wishes. Now, on to the component of informed consent, and this is the last element of consent. Doctors have an unequivocal duty, and this is out of Vale versus Hughes, the Supreme Court of Canada case, to inform the patient of material risks. To inform the patient of material risks and other important information prior to obtaining consent. So the doctrine of informed consent contains layered principles housed within the general doctrine of consent and should not be conflated with invalid consent. Where the patient is not informed, battery is likely to arise. Where a patient is inadequately informed, negligence is usually what comes up. And so in Smith versus Tweedale, the Court of Appeal in BC opined that two conclusions underpin the propriety of the trial judge's decision that the doctor was negligent. The first, and I quote from the decision, was that by requesting to have her tubes tied, and this goes to what I was talking about a moment ago, the plaintiff essentially conveyed to the defendant her own preconceived notion that the procedure in question was reversible. And thus the defendant was placed on notice that more than his usual presentation was required. The evidence established that the expression tubal ligation, which I'd never heard before this case, is a general term which covers a number of different procedures which have different consequences, ranging all the way from complete irreversibility to reversibility with a 50% chance of future pregnancy, et cetera, medicine advances, things change. At the end of the day, it's quite a bit different than an IUD or the birth control pill. The second conclusion was that in the circumstances in which the plaintiff found herself after 13 hours of difficult labor and lying on a delivery table, more than just a routine explanation of the procedure was needed. And we would say that because of the circumstances of labor and the impact, creating a diminished capacity due to stress, physical pain, all kinds of things, that it is not the time ever to have that discussion. And this is especially true for Indigenous women and other women of color. And I'll tell you why. Because there's a lot of evidence out there that talks about how discrimination and racism experienced over one's life generates a form of PTSD. And that PTSD usually manifests in fight or flight, which is a rather typical symptom of PTSD from my understanding when faced with stressors or triggers. Now, when a woman is physically incapacitated and giving birth, fight or flight is not possible. So what will you see? You will see unusual compliance, fear, etc. Also, women who have been sexually assaulted or abused can be triggered by childbirth. And unfortunately, that's something that happens far too often to the women and men and others in our community. And so there has to be an increased understanding that a birthing Indigenous woman will have sensitivities and needs that may not be like everybody else's, but they are needs nonetheless. And so with respect to the informed consent component, all options have to be shared. We can't do that when a woman is between contractions or heading into a C-section that is emergency or scheduled, that's major surgery. You cannot have a meaningful discussion about what you want to do with the rest of your reproductive life when you are in the middle of giving birth. And I use this anecdotally. I said, while I was giving birth, I asked to be put out of my misery, but that wasn't consent to assisted suicide. Might be a brash comparison, but it's true. It's rough. And when people have received either stressful news, a diagnosis, etc., everybody knows that it's not the time to start talking about options right away, that people need time to absorb it. Same thing can be said for women who are in the process of birthing. And so In another case, in Murray versus McMurtry, which was in 1951, it established that a patient undergoing surgery with respect to her reproductive organs had the right to consent to all procedures associated with the same. And so what I've heard here and there is that tacking on a tubal ligation to cesarean section is better because you don't have to put the woman under twice. But it's irrelevant. It's irrelevant because she has the right to consent to all procedures. And consent, like I said, is not an event, it is a process. And so that process must be engaged, and it cannot be while a woman is delivering. So in that case, the patient had undergone an operation to have a cyst removed from one of her ovaries. The physician, while operating, discovered additional fibroids and took the liberty of tying both her fallopian tubes on the basis of his justification that there was an increased risk for an ectopic pregnancy. This had not been discussed with the patient. The court determined that the patient, by virtue of her inalienable right to bodily autonomy, had the right not to be subjected to the secondary procedure without her consent. Convenience to the physician did not operate to cure the battery, which the court ultimately found had been inflicted upon the patient. And so Millett versus Shulman, which I discussed a little bit earlier, was a case where the procedure was in effect life-saving. But the court there found that treatments cannot be administered in circumstances where the nature of such treatment is in contravention of a person's conscience and religious beliefs, and where such beliefs are known to the physician to be going against the will of the patient. Now, it doesn't get complicated at all, but if we examine, the situation of Indigenous women and other women of color, and we look at the statistics associated with birth alerts, child apprehensions before that baby is 30 days old, what you have is a clear concern and worry going into the birthing process that others may not. I myself, as a lawyer dressed in a three-piece suit, still those thoughts come in, and I think, you never know, you never know. What are they going to say? And that's a part of historical trauma that carries through. And I can tell you from personal experience, when our babies were born, that my husband, as soon as the baby came out, followed the baby absolutely everywhere, would not let anyone take that baby anywhere out of his sight. And that's because of the stories we know, of the people we've lost, of things that have been done and passed down in our families, that hypervigilance remains extremely active. And so there are some things that have to be understood. And I used to have to really explain this before, but I feel with the news of last week that I probably don't. I'm hoping that those who are on this call will understand that what Indigenous communities have experienced have created a measure of collective trauma that is plucked and triggered on a regular basis, and that trauma may very much come to the surface during birth, where a woman without trauma is in a state. And so all other things being equal, it is still difficult. So those are the elements of consent. And what I can tell you is that what we've learned with recent legislation that has been passed on medical assistance in dying is that consent was a really critical component of that, because of course, the results of medically assisted dying are absolutely permanent. And the elements of consent were front and center there. We have to make sure that the patient agrees, that they have thought about it, that they have capacity, that, they've gotten a second opinion, what have you. And what we're saying here in the case of birthing women is that while they are in that bubble, while they're in the peripartum period and they're experiencing pain, sleep deprivation, which often happens in your last month of pregnancy, triggers with respect to any form of post-traumatic stress disorder they may have, whether it arises from collective trauma or historic trauma or individual trauma, and the physical act of birthing itself in relation to how painful it is, how stressful it is, how anxiety producing and overwhelming it is, it's not the right time. It's not the right time to have that conversation. And in the case of the women that we represent, which are over 100 now in number, that conversation wasn't even had. There was no suggestion of alternative methods. There was no talk about what their bodies might go through. There was not a chance. It was, you have to do this because I said so, sign here. If that even happened. In one of our cases, the woman gave birth to her sixth child naturally, was brought into the operating room against her wishes, against her protest. She was tied down, her arms were tied down, and she was sterilized without her consent, asking throughout, are you done yet? Are you done yet? And when the physician finished, he said, there, cut, tied, and burnt, nothing is getting through that. And she suffers with that still. 20 years later, she suffers with that. She can't go see a doctor. She's so afraid of seeing doctors. And I think what is really important is that as doctors coming in and as those people carrying such a great responsibility, it is very important to understand that another person's body is never something that you get to make a decision about unless you absolutely have to. So that is my presentation on the elements of consent. So maybe what I can do now is go through the questions, if that makes sense. Pervasiveness of neo-eugenics here in Saskatchewan. Is there any data on how much do physicians understand and apply the elements of consent in Saskatchewan? Well, what I can tell you is I moved here about 8-9 months ago, and my observations as a person and my observations in the profession, coming from an Ontario setting and being a maritime or a Mi'kmaq from the Maritimes, is that, Saskatchewan is a rather racist place, comparatively speaking. I don't think this is a secret. I think that the relations here are very strained. In my territory, we often say we don't have a bad relationship with the state. We just have no relationship with the state. Here, I think from my observations is that there is a very bad relationship with the state, and that has existed from the time that Cree warriors in the Battlefords were hung and Indian residential school students were brought to watch it happen in the late 1800s. Up until very recently, dealing with Colton Boushie's death, to the over-incarceration of Indigenous people here, to the 78% of children who are apprehended before 30 days old from hospital are Indigenous children. There are still a lot of social problems that I think are fueled by this idea that one group of people knows better than the other. And so, as far as, is there any data on whether or not physicians understand and apply the elements of consent? I doubt it. But what we do see is, pending class action, and that might suggest that the understanding is not as deep as it must be. I see here in healthcare, Indigenous patients are often signaled as non-compliant. Manuela, do you want to explain that question a little bit so that I answer it correctly?
Well, no, it was more a comment about this power relationship and how consent is kind of like constructed within that power relationship and authority of doctors and nurses, and how not only in healthcare, but also in social services, Indigenous people are usually coded as non-compliant.
Mm-hmm. I've seen that often. I've often seen that. And non-compliance might just be, no, I don't want that. Right? It's not, and it's not a question of persuading. It's a question of respecting, right? And as long as the consequences are clearly explained, there's even the opportunity to have people sign waivers. Listen, saying, I explain this all to you in a way that you understand. This is what you're confirming. If a translator is needed, you have that. If an interpreter is needed, you need that. You have that. And to be honest, I want people to understand here that just because some of our people or too many of our people don't speak their Indigenous language doesn't mean they understand what you're saying to them. There's a way of explaining things that has to be, and I mean, I face this in legal practice all the time, right? You have to explain it in a lay manner. And sometimes it's not as nuanced as you want it to be because you understand as a professional that it's more complicated than that. But focusing on accessible language is absolutely quintessential to providing the information that patients have a right to obtain. And if you can't do that, that's fine. It's really hard, but bring in the help that you need. Bring in the help that you need to get that message across so that that patient understands what you're recommending, what you're proposing, and what the options are so that they can make a decision that they sit well with. Here I see a question from Abukari Kwame. I hope I said that right. That says, if I would like to comment on individual versus collective rights around consent. In many societies and cultures, healthcare decisions may not largely be based on the individual patient. How does the concept of consent respect cultural values of collective responsibility in healthcare decision-making? Well, in Canada, the Canadian Charter of Rights and Freedoms applies to individual people. And so an individual person has the right to inalienable bodily autonomy unless those elements of consent are satisfied. And so the culture, the society from which that person comes may feel, any kind of way about what it is that they want to do. But again, that goes back to the voluntary consent component where there cannot be any coercion, including from the physician or the nurses or any other attending staff. And so that is not a concept that really exists in our law. There is no deference to a cultural group. And if a physician is not sure that that consent or lack of consent is authentic and genuine and coming from that individual, then as I was saying earlier, that conversation should happen alone to make sure that it is truly reflective of that person's wishes. And if they can't get there, as it relates to sterilization anyway, what is the rush? There's absolutely no rush. So is there anything that needs to be further emphasized for students learning about consent in their ethics courses, particularly given the lack of anti-racism? There's no anti-racism training at USask? Can someone answer that?
We're working on it.
Yeah, okay, so
there is currently a course offered to physicians and students called The Role of the Practitioner in Indigenous Wellness. But it's on a culturally responsive framework. It's not anti-racism yet, but we're introducing some elements.
I think something that I've often said, these are systemic issues. And so systemic and institutional issues require systemic and institutional responses, in my respectful opinion. And so it's less a question about what our culture dictates and more of a question of what the institutional culture dictates and why our bodily autonomy is not respected in those processes. I don't think that, and I'm being very frank because I don't know how else to be, I'm a pretty direct, transparent person. I don't think that learning more about Indigenous people and culture, when we're faced with the legacy of eugenics and issues surrounding the implementation of the elements of consent, are going to be terribly useful. I think that accountability within the institutions themselves to abide by the law and to respect bodily autonomy is what has to happen. So culture, I think the only culture that requires close examination is the culture of medicine in this respect. I wish smudging helped us all to understand each other better. But I think that the focus point has to be on the people doing the wrong, not the people suffering the wrong. We'll heal in the way that we have to. Our clients will heal in the way that they have to. And we will try to prevent this from happening. But institutions cannot, in my respectful opinion, hinge their systemic reform based on a greater understanding of our people. I think that's nonsense. I think it's nonsense. And I think it's frankly rather dishonest. And so I'm hopeful that those cultural discussions turn inward, that they don't look externally for some kind of epiphanical moment or piece of epiphanical information that will somehow change their views about how human we are, if that makes any sense. Second generation settler. Oh, manifestation of the PTSD might be interpreted as non-compliance. Yeah, that's true. Could be. I don't know. I've been present for 2 births and they were my own. So I can't talk to you much, and I don't remember all of them. And I don't remember them clearly because it was a time. So an RN working with an Indigenous housing program in Saskatoon. They use drugs and alcohol or other influence at almost all times. I respect their autonomy and consent. But can I get valid consent from someone who is using drugs? Or no, especially with the vaccine rule. Yeah. I mean, the law is pretty clear. If someone is under the influence of alcohol or any kind of drug, prescription or otherwise, that consent is in, that capacity is impaired. So the question then would depend, is that procedure life-saving? And it's always contextualized that way, is what is the nature of the procedure? Is it essential? Is it life-saving? Is it therapeutic? Is it elective? All those things matter. And so I would never purport to provide any form of medical advice. So things like the HIV treatment, question becomes, is it life-saving? Is it essential? And I think that you're in the best position to determine that. But again, at the end of the day, bodily autonomy is inalienable. Oh, that was a direct message. Courses in ethics. So the question is, I personally think that for informed consent, there's a disconnect between what medical students are taught in the courses that discuss ethics versus the courses that discuss investigations, treatment, and management of medical conditions. Could very well be. Could very well be. But if I were to give you an example, when I have a client, I don't launch a suit without getting their absolute consent first. And I sit down and I explain what the suit is about, what the recommendations are. And I can't do that if they're not in the right headspace. So here I see my experiences with medical consent is that is written, expressed in a way that assumes medical prerogative and that the individual has to say no to what is structured as normal. Any comments to the implicit pressure inherent in this system? Yeah, it's problematic. And it's problematic because the legal framework doesn't support that. I mean, clearly we don't know as patients what we don't know. We rely on the knowledge of doctors, but we also rely on their respect for the law and our bodily autonomy. And so I think with respect to that, if there's anything that has been taken away from this, is that a woman who's in the throes of labor, don't ask her if she wants to do that again while she's doing it. Give her a minute. Give her a minute. I think that's the common sense approach to it. I don't think that tubal ligations should be proposed to women who are in labor. I don't think they should be proposed to women who are recovering in the immediate aftermath of childbirth or while they're heading into even a scheduled C-section. I think that that stress diminishes capacity, and I think that consent is vitiated. And so any kind of implicit pressure, you have to understand, is occurring within the context of a fiduciary relationship. And in the context of a fiduciary relationship, any kind of implicit pressure to the patient is going to feel like a direction and is going to be interpreted as such by many. And so the non-compliance might be stark. They're saying, no, I'm tired of getting told what I need to do. I don't want to do any of that. I'm done. Or it might just be complete compliance. Do whatever you need to do. Do whatever you need to do. Just, let me come out of this alive is usually what's on the forefront of people's minds. And so I'm hopeful that that was helpful.
Alisa, I think we're going to have to bring you back because there's so many more questions and this conversation is so important and interesting.
Anytime.
So can I invite everybody maybe to give a round of applause to Alisa, virtual or real?
Thank you.
Yeah, I just want to thank you also so much, Alisa, for being here. This was so informative, and I agree with Manuela. I think we should bring you back next year, and I know the College of Law actually expressed quite a bit of interest, so maybe we do that. Just thanks everyone for coming. I have put a link to a quick feedback form. It should take no more than 2 minutes. It's really helpful and provides us lots of feedback. And yeah, I'm just really grateful for you to be here with us, and wish everyone a wonderful rest of your day and weekend, and take care of yourselves and each other. All right, bye everybody.
Take care of yourselves, everyone. Be kind to yourselves.